I never thought I would end up in a screaming match with the HOA president on my own private island. But there I was on a humid Tuesday morning in June, standing on the rocky shore while a 50-something woman with a blonde bob haircut and yoga pants pointed her perfectly manicured finger at me like I had committed some kind of federal crime. My name is Ethan Rosewood, and I had moved to Lake Geneva, Wisconsin 6 months earlier after inheriting my grandfather's estate. The property was unusual, to say the least. It consisted of a modest lakefront house and a small island about 200 yards offshore. The island was only about 3 acres, covered in old-growth oak trees and wild raspberry bushes, with a little wooden dock and a stone cottage my great-great-grandfather had built back in the 1890s. I had fallen in love with the place the moment I saw it. The lake community had an HOA, which I knew going into the purchase. I paid my dues on time, kept my lawn trimmed, and generally stayed out of everyone's business. I worked remotely as a software developer, so I spent most of my time either in my home office or kayaking out to the island where I could think and work in complete silence. It was paradise. That all changed when Patricia Newhouse became the HOA president in April. Patricia was the kind of person who volunteered for positions of minor authority, and then wielded that power like she was running a military dictatorship. She had already sent violation notices to half the neighborhood for infractions ranging from mailboxes being the wrong shade of black to someone planting petunias instead of the approved marigolds in their flower beds. I first heard from her 3 weeks after she took office. She knocked on my door one Saturday morning while I was making coffee, wearing a pristine white tennis outfit and carrying a leather portfolio that probably cost more than my monthly mortgage payment. "Good morning, Ethan," she said with a smile that did not reach her eyes. "I am Patricia Newhouse, the new HOA president. I wanted to introduce myself and discuss some community matters with you." I invited her in, figuring this was just a meet and greet. I was wrong. She sat down at my kitchen table without being asked and pulled out a stack of papers from her portfolio. "I have been reviewing all the properties in our community, and I noticed something concerning about your lot. According to the HOA bylaws established in 1973, all islands within the community boundaries are designated as common recreational areas for use by all residents." I nearly dropped my coffee mug. "I am sorry. What? The island is part of my private property. It has been in my family for over 100 years. Patricia shook her head with that condescending smile people use when they think you are an idiot. "I understand you may have believed that, but the HOA bylaws are quite clear. The island falls within our jurisdictional boundaries, which means it is subject to our regulations. I will be scheduling a community meeting next month to discuss opening the island for recreational use. Picnics, swimming, perhaps a small pavilion." "You cannot be serious," I said, feeling heat rising in my face. "That island is mine. My great-great-grandfather bought it in 1892. I have the deed." "Deeds can be superseded by HOA covenants," Patricia said smoothly, standing up and collecting her papers. "I suggest you review the bylaws. We will discuss this further at the meeting. Have a wonderful day." She left before I could argue further. I immediately went to my filing cabinet and pulled out all the property documents I had inherited. The deed was there, yellowed with age but perfectly legible. It clearly stated that Cornelius Rosewood had purchased the lakefront property and the adjacent island in September of 1892 for the sum of $300. Every subsequent transfer of the property, including the most recent one to me, specifically mentioned the island. I spent the rest of the weekend researching HOA law in Wisconsin. What I found was both reassuring and alarming. While HOAs did have significant power over properties within their jurisdiction, they could not simply claim private property without legal basis. However, if the original developer of the HOA community had somehow included the island in the common areas when the association was formed, things could get complicated. The community meeting happened on a Wednesday evening in early May at the local community center. About 40 residents showed up, most of them retirees who treated these meetings like prime-time entertainment. I sat in the back row, my folder of documents on my lap, waiting for the island discussion. Patricia ran through the usual business first. Someone had painted their front door navy blue instead of the approved midnight blue and would need to repaint. Another resident had installed a bird feeder that was 3 inches too tall according to the community standards. The violations went on for nearly an hour. Finally, Patricia pulled up a slide showing an aerial view of the lake. Now, I want to discuss an exciting opportunity for our community. As many of you know, there is a beautiful island just offshore from the Rosewood property. This island has been sitting unused and inaccessible to our residents for far too long. After careful review of our bylaws, I have determined that this island should be classified as common area property, available for all residents to enjoy. Murmurs of excitement rippled through the crowd. I stood up. "That island is my private property," I said loudly. "It has been in my family since 1892. I have the original deed." Patricia turned to me with that smile again. "Mr. Rosewood, I understand your confusion, but the HOA bylaws established in 1973 clearly state that all islands within the community boundaries are common areas. Your grandfather may have used the island, but that does not mean he owned it." "My grandfather did own it," I said, walking forward and holding up the deed. "And so did his father and his grandfather before that. This document proves continuous ownership for over 130 years. Patricia waved her hand dismissively. "A deed from the 19th century has no bearing on modern HOA regulations. The community association has jurisdiction over all properties within its boundaries, including islands. Unless you can prove that the island was specifically exempted from HOA control when the association was formed, it defaults to common area status." "That is not how property law works," I said, my voice rising. "You cannot just declare someone's private property to be communal land because you want to have picnics there." An older man in the front row raised his hand. "I think it would be wonderful to have access to the island. My grandkids would love it." A woman next to him nodded enthusiastically. "We could put in a nice walking path and maybe some benches." I could not believe what I was hearing. These people were discussing improvements to my property like I was not even there. "This is insane," I said. "That island is mine. I have a legal deed. You cannot take it." Patricia's smile finally dropped. "Mr. Rosewood, I suggest you consult with an attorney if you wish to contest this. However, I am confident that our position is legally sound. In the meantime, I am proposing that we form a committee to explore recreational development of the island." "All in favor?" 32 hands went up. I walked out of the meeting shaking with anger. This could not be legal. There was no way an HOA could just claim a piece of property that had been privately owned for over a century. But as I drove home, a nagging worry started to form. HOAs had done crazier things. I had read horror stories online about associations foreclosing on homes over unpaid dues, banning vegetable gardens, and imposing thousands of dollars in fines for minor violations. If Patricia had the support of the community and a lawyer willing to argue her case, I could be in for a serious fight. The next morning, I called every real estate attorney in Lake Geneva. The first three told me they could not take my case because they had existing relationships with the HOA. The fourth, a sharp-eyed woman in her 60s named Margaret Chen, agreed to meet with me that afternoon. I brought all my documents to her office and laid out the situation. Margaret listened carefully, occasionally making notes on a legal pad. When I finished, she leaned back in her chair and steepled her fingers. "This is fascinating," she said, "and completely absurd. Patricia Newhouse does not have a legal leg to stand on. Your deed predates the HOA by 81 years. There is no way the association can claim ownership or control of property that was privately owned long before the HOA even existed." Relief flooded through me. So what do I do? First, I am going to send a cease and desist letter to the HOA board, clearly stating that any attempt to access, develop, or claim ownership of your island will result in a lawsuit for trespassing and violation of property rights. Second, I am going to request copies of all HOA bylaws, covenants, and founding documents to see what legal basis they think they have for this claim. My guess is they have none, and Patricia is either woefully ignorant of property law or deliberately trying to bully you into giving up your rights. "Why would she do that?" I asked. Margaret shrugged. "Some people love power. An HOA presidency is often the only authority they will ever have, and it goes to their heads. She probably thought you would just roll over and let her have the island rather than fight. Unfortunately for her, you have the law on your side." I left Margaret's office feeling much better. The cease and desist letter went out the next day. I thought that would be the end of it. I was very wrong. 2 weeks later, I looked out my kitchen window and saw something that made my blood boil. There were people on my island. Not just 1 or 2 people, but at least a dozen residents, including Patricia, having what looked like a full-scale picnic. They had brought folding chairs, coolers, and even a portable grill. I grabbed my phone and called Margaret. "They are on my island right now." "What do I do?" "Call the police and report them for trespassing," she said immediately. "And do not confront them yourself. Let law enforcement handle it." I called the Lake Geneva Police Department and explained the situation to the dispatcher. 20 minutes later, a patrol car pulled up to my house. Officer David Martinez listened to my explanation and examined the deed I showed him. "So you are saying all those people out on the island are trespassing on your private property?" he asked. "Yes," I said. "I have asked them repeatedly to stay off the island, but the HOA president claims it is common area property." Officer Martinez looked out at the island and sighed. "This is really a civil matter, not a criminal one. The best I can do is go out there and ask them to leave, but I cannot arrest anyone unless they refuse or become violent." "That is fine," I said. "I just want them off my property." The officer took a boat out to the island. I watched from my deck with binoculars as he spoke with Patricia and the other residents. I could not hear what was being said, but I could see Patricia gesturing emphatically and shaking her head. The conversation went on for nearly 15 minutes. Finally, the group started packing up their things. They did not look happy about it. Officer Martinez returned to my house. "They are leaving, but the HOA president wants you to know she will be taking legal action. She claims she has documentation proving the island is HOA property." "She is lying," I said flatly. "My attorney has already sent a cease and desist letter. Like I said, this is a civil matter. You folks will need to work it out in court, but for now they are off your island." After the officer left, my phone started ringing. It was a number I did not recognize. I answered it. "Mr. Rosewood, this is Patricia Newhouse. What you did today was completely unnecessary and hostile to the community. We were simply exercising our rights to enjoy common area property." It is not common area property, I said, fighting to keep my voice level. It is my private island. I have a deed from 1892. That deed is meaningless, Patricia snapped. I have consulted with our HOA attorney, and he assures me we have full legal rights to the island. You are going to lose this fight, Mr. Rosewood. I suggest you accept reality and stop antagonizing your neighbors. My neighbors are welcome to use the public beach like everyone else, I said, but they do not get to trespass on my property just because you told them it was okay. Patricia's voice turned icy. You will regret this. I promise you that. She hung up. I immediately called Margaret and told her about the trespassing incident and Patricia's threats. Good, Margaret said. Let them take legal action. I would love to see what their attorney thinks he can argue in court. In the meantime, I am filing for a temporary restraining order to keep the HOA and all residents off your island until this is resolved. The legal wheels started turning slowly. Margaret filed the paperwork for the restraining order, and we were given a court date for a hearing 3 weeks away. In the meantime, I installed no trespassing signs around the island's perimeter and set up a few trail cameras to document any further violations. The cameras paid off almost immediately. Over the next 2 weeks, I caught footage of at least 8 different residents trying to access the island. Most turned back when they saw the signs, but 3 actually landed on the island and walked around before leaving. One of them was Patricia herself, who spent nearly an hour inspecting the old stone cottage and taking photographs. I sent all the footage to Margaret, who added it to our case file as evidence of ongoing trespassing and harassment. The restraining order hearing was held in Walworth County Circuit Court on a hot morning in late May. I arrived with Margaret to find Patricia and a lawyer I did not recognize already seated at the defendant's table. Patricia looked supremely confident, like she had already won. The judge, a gray-haired man named Judge Robert Thornton, called the hearing to order and asked Margaret to present our case. She stood and laid out the facts clearly and concisely. I owned the island through a valid deed dating back to 1892. The property had been continuously owned by my family for over 130 years. The HOA had no legitimate claim to the property and was engaging in repeated trespassing and harassment. Your Honor, I have copies of the original deed, all subsequent transfers, and current property tax records showing that my client pays taxes on both the mainland property and the island as a single parcel, Margaret said, handing a stack of documents to the bailiff. There is absolutely no legal basis for the HOA's claim. Judge Thornton examined the documents carefully. Then he turned to Patricia's attorney, a thin man in an expensive suit named Gerald Foster. Counselor, what is your response to this? Gerald stood up and cleared his throat. Your Honor, while the plaintiff may possess a historical deed to the island, that deed does not supersede the authority of the Homeowners Association. When the Lake Geneva Shores HOA was established in 1973, the founding documents specifically designated all islands within the community boundaries as common recreational areas. This was done to ensure that all residents would have equal access to the lake's natural resources. Do you have a copy of these founding documents? Judge Thornton asked. Yes, Your Honor. Gerald handed over another stack of papers. The judge read through them silently for several minutes. I tried to read his expression but could not tell what he was thinking. Finally, he looked up. Mr. Foster, I have reviewed your HOA bylaws and covenants, and nowhere in these documents do I see any reference to islands being designated as common areas. There is a general provision about common areas, including shoreline access points and the community beach, but nothing about islands. Gerald's confident expression faltered slightly. Your Honor, the designation is implied by the geographical boundaries of the HOA jurisdiction, which include the water areas around the community properties. Implied is not the same as explicit, Counselor, Judge Thornton said dryly. Property rights are not implied. They are documented and recorded. Mr. Rosewood has clear title to this island dating back to 1892. Unless you can show me a specific legal document transferring ownership or control of that island to the HOA, your client has no claim. Your Honor, we believe that the island's location within the HOA boundaries subjects it to association control. Gerald tried again. Being located within an HOA's geographical area does not automatically make private property subject to HOA control beyond normal covenant restrictions, the judge said, his patience clearly wearing thin. Mr. Rosewood's island is his private property. The HOA may have jurisdiction over what he can build there, or how he maintains it under normal HOA rules, but you certainly cannot claim the land itself as common area property. That would be tantamount to theft. Patricia jumped to her feet. Your Honor, this is outrageous. The community has rights. The community has the rights explicitly granted in your covenants and bylaws, Miss Newhouse, Judge Thornton said sharply. Sit down. Patricia sat, her face flushed red with anger. Judge Thornton turned back to Margaret. I am granting your motion for a temporary restraining order. The HOA and all its members are prohibited from accessing, trespassing on, or attempting to claim ownership of the island property until this matter is fully resolved. If I see any evidence of violations, I will hold the responsible parties in contempt of court. Is that understood? Yes, Your Honor, Margaret said. Mr. Foster, the judge prompted. Yes, Your Honor, Gerald said quietly. Good. I am also ordering both parties to attempt mediation before this goes to a full trial. Perhaps cooler heads can prevail. Court is adjourned. I walked out of the courthouse feeling vindicated but exhausted. Margaret was grinning. That went even better than I expected, she said. The judge basically laughed their case out of court. If they have any sense at all, they will drop this nonsense and issue a formal apology. Somehow I doubt Patricia is going to do that, I said. I was right. Over the next few days, I started receiving anonymous letters in my mailbox. They were all variations on the same theme. I was selfish, greedy, and anti-community. I was depriving children and families of a beautiful recreational space just so I could have my own private playground. One letter called me a modern-day feudal lord who thought he was better than everyone else. I also noticed that several of my neighbors stopped waving when they drove past my house. The friendly woman who lived 3 doors down and used to chat with me about gardening now glared at me when I got my mail. The community had turned against me, and I knew exactly who was responsible. The mandatory mediation session was scheduled for mid-June. I met Margaret at the mediator's office, a bland conference room in a business park near the lake. Patricia arrived with Gerald Foster and 2 other HOA board members, a man named Richard Benton and a woman named Susan Calloway. The mediator, a calm, middle-aged woman named Jennifer Park, explained the process and asked each side to present their position. Margaret went first, reiterating the facts of my clear ownership and the HOA's baseless claim. Then it was Patricia's turn. This is not just about legal technicalities, Patricia said, her voice taking on a passionate tone. This is about community values. Ethan Rosewood has a beautiful natural resource sitting unused 200 yards from shore. Meanwhile, our community members, many of whom are elderly or have young children, have no access to any island recreation. It is selfish and wrong. Miss Newhouse, whether or not you think it is selfish is irrelevant, Jennifer said gently. The question is whether you have any legal claim to the property. We have the community's support, Patricia said. We took a vote, and over 80% of residents believe the island should be available for everyone to enjoy. A community vote does not override private property rights, Margaret said. You could have 100% of residents vote to take Mr. Rosewood's car and it would still be theft. Patricia's face flushed. That is a ridiculous comparison. It is actually a perfect comparison, Margaret said calmly. You are attempting to seize private property without legal justification. The only difference is scale. The mediation went downhill from there. Patricia refused to acknowledge that she had no legal basis for her claim, and I refused to even consider granting the HOA any kind of easement or shared access to the island. After 3 hours of circular arguments, Jennifer Park finally called it. I do not think we are going to reach an agreement today, she said with a sigh. I will file a report with the court stating that mediation was unsuccessful. This will proceed to trial. As we gathered our things to leave, Patricia approached me directly, ignoring Margaret's warning hand on my arm. You are making a huge mistake, she said quietly. The community will not forget this. You are going to be very unhappy living here. Is that a threat? I asked. It is a fact, Patricia said. Good luck, Mr. Rosewood. You are going to need it. Over the next 2 weeks, life in the Lake Geneva Shores community became increasingly uncomfortable. I received more anonymous letters, including one that contained photographs of me taken through my windows. Someone scattered nails in my driveway, giving me 2 flat tires. My garbage cans were knocked over repeatedly, spilling trash across my yard. I filed police reports for all of it, but Officer Martinez told me there was little they could do without evidence of who was responsible. The worst incident happened on a Saturday morning in late June. I woke up to go kayaking and found that my kayak, which I kept locked to my dock, had been vandalized. Someone had taken a knife or saw to it and cut deep gashes into the hull, making it completely unusable. They had also spray-painted "Share the Island" across my dock in huge red letters. That was the final straw. I called Margaret immediately. This has gone beyond a property dispute, I told her. Patricia is actively encouraging people to harass and vandalize my property. We need to do something. I agree, Margaret said. I am going to file a motion to expedite the trial date and also request additional penalties for the HOA based on their pattern of harassment and intimidation. Keep documenting everything. Take photos, save all the letters, and keep filing police reports. We are going to need all of it. The trial was moved up to early August. In the meantime, I installed security cameras around my entire property and stopped going to the island altogether. It broke my heart to stay away from the place I loved, but I did not want to give Patricia any excuse to claim I was somehow preventing community access. The cameras caught 2 more incidents of vandalism. In one, a teenager I did not recognize threw eggs at my house at 2 in the morning. In another, someone tried to cut my internet cable. I handed all the footage over to the police and to Margaret. As the trial date approached, I received a surprising phone call from Richard Benton, one of the HOA board members who had been at the mediation. Mr. Rosewood, I hope you do not mind me calling, he said. I wanted to talk to you off the record. About what? I asked warily. About Patricia and this whole island situation. I voted against pursuing this case for what it is worth. I think she is way out of line. Several of us on the board do. But Patricia is very forceful, and she has convinced most of the community that you are some kind of villain. So why are you calling me? I asked. Because I think you should know what is really going on, Richard said. Patricia does not actually care about community access to the island. Her brother-in-law is a real estate developer. She wants to get control of the island so she can develop it into a private event venue and rent it out for weddings and parties. She has been shopping the idea around to investors for months. I felt my stomach drop. You are kidding. I wish I was. She has a whole business plan drawn up. She figured if she could get the HOA to claim the island, she could then get herself appointed as the manager of the property and essentially run it as her own business while hiding behind the HOA as legal cover. That is fraud, I said. That is Patricia, Richard said tiredly. Look, I cannot testify to any of this or make an official statement because I have no hard proof. But I thought you deserved to know what you are really dealing with. This is not about community values. It is about money. Thank you for telling me, I said. I appreciate it. After Richard hung up, I immediately called Margaret and relayed the conversation. She was silent for a long moment. If what he is saying is true, this changes everything, she said finally. We need proof. Can you think of any way to get documentation of this development plan? I thought about it. Maybe. Patricia is president of the HOA, which means she probably stores HOA documents at her house. If the business plan mentions using HOA land or authority, it might be mixed in with official HOA paperwork. We cannot break into her house, Ethan, Margaret said firmly. I know that, but HOA records are supposed to be available to all homeowners on request, right? Technically, yes. You are entitled to review meeting minutes, financial records, and governing documents. Then, I am going to request access to all HOA records for the past year, I said. If her development plan is mixed in with the official paperwork, it would be legitimate discovery. Margaret agreed to draft a formal records request. We sent it to the HOA board the next day, citing Wisconsin state law that required HOAs to make records available to homeowners within 10 business days. Patricia's response came within an hour. It was a one-sentence email. Your request is denied as frivolous and harassing. Perfect, Margaret said when I showed her. She just violated state law. I am filing a motion to compel production of records and adding sanctions for non-compliance. This is going to look terrible for her in front of the judge. The motion hearing was scheduled for a week before the trial. Judge Thornton was clearly not pleased to see the same parties in his courtroom again so soon. Miss Newhouse, Wisconsin state statute is very clear about homeowner access to HOA records, he said after hearing Margaret's motion. What possible justification do you have for denying Mr. Rosewood's request? Patricia stood up, and I could see her struggling to maintain her composure. Your Honor, Mr. Rosewood is not making this request in good faith. He is simply trying to harass the HOA and dig up information to use against us in the trial. Mr. Rosewood is a homeowner in your association, Judge Thornton said. He has every right to review HOA records regardless of his motivation. The law does not require good faith for records requests. It simply requires that he be a member of the association. But Your Honor, Miss Newhouse, I am ordering you to produce all requested HOA records to Mr. Rosewood's attorney within 3 business days. If you fail to comply, I will hold you personally in contempt and impose sanctions. Do you understand? Yes, Your Honor, Patricia said through gritted teeth. 3 days later, Margaret received 8 boxes of HOA documents. We spent an entire afternoon going through them in her office, sorting through meeting minutes, financial statements, and correspondence. We were about halfway through the 5th box when Margaret suddenly stopped and held up a folder. Ethan, look at this. Inside the folder was a detailed business plan titled Island Paradise Events, a Lake Geneva destination venue. It laid out exactly what Richard had described. A plan to develop my island into a high-end event venue with a renovated cottage, landscaped gardens, and a dock for boat access. The financial projections estimated revenues of over $500,000 per year from wedding and event rentals. The plan was authored by Patricia Newhouse and someone named Gregory Marsh. A quick internet search revealed that Gregory Marsh was indeed Patricia's brother-in-law and the owner of a development company called Marsh Properties LLC. But it got even better. The folder also contained emails between Patricia and Gregory, discussing how to acquire control of the island property through HOA mechanisms and minimize legal exposure while maximizing development potential. One email explicitly stated, "Once the HOA claims the island as common property, I can be appointed as manager and we can move forward with development under the association's legal umbrella." "This is unbelievable," Margaret said, reading through the emails. She was planning to use her position as HOA president to steal your property and develop it for personal profit. This is fraud, breach of fiduciary duty, and probably a few other things I will think of once I consult my references. "Can we use this in the trial?" I asked. "Oh, we are definitely using this in the trial," Margaret said with a fierce smile. "And I am also sending a copy to the State Attorney General's office. If they want to pursue criminal charges, they will have plenty of evidence." The trial began on a scorching hot Monday in early August. The courtroom was packed with Lake Geneva Shore's residents who had come to watch the spectacle. Patricia sat at the defendant's table looking confident, clearly expecting to win over the judge with appeals to community values. Margaret delivered our opening statement, laying out the facts of my ownership and the HOA's baseless claim. Then Gerald Foster delivered the HOA's opening, arguing that modern community standards and the will of the residents should take precedence over ancient property deeds. The first witness Margaret called was me. I testified about my family's history with the property, the continuous ownership since 1892, and the harassment I had experienced since Patricia began her campaign to claim the island. Gerald Cross examined me aggressively, trying to paint me as an elitist who refused to share resources with my neighbors. "Mr. Rosewood, is not it true that you use the island only occasionally, perhaps a few times per month?" "I used to go there several times a week," I said. "But I have been staying away because of the ongoing legal dispute and the vandalism to my property." "Alleged vandalism," Gerald corrected. "I have photographs and police reports documenting all of it," I said evenly. Margaret's next witness was a property law expert from the University of Wisconsin, who testified that pre-existing deeds absolutely took precedence over HOA bylaws, and that no association could claim privately owned property without explicit legal transfer. Then came the surprise. Margaret called Richard Benton to the stand. I had not known she was going to do this. Richard looked nervous as he was sworn in, and Patricia stared at him with an expression of pure betrayal. "Mr. Benton, you are a member of the HOA board, is that correct?" Margaret asked. "Yes, I am the treasurer." "In your capacity as a board member, have you had access to discussions about the island property and the HOA's plans for it?" "Yes, I have." "Can you tell the court what those discussions involved?" Richard took a deep breath. "Patricia, our president, has been talking for months about developing the island into an event venue. She has a business plan drawn up with her brother-in-law. The whole point of claiming the island as HOA property was so she could control it and use it for this private business venture." The courtroom erupted in gasps and whispers. Judge Thornton banged his gavel for silence. Patricia's face had gone from red to white. "Objection, Your Honor." Gerald jumped to his feet. This is hearsay and irrelevant to the property claim. It goes directly to the motivation and good faith of the HOA's claim. Your Honor, Margaret said smoothly, and I have documentary evidence to support Mr. Benton's testimony. She produced copies of the business plan and emails we had found in the HOA records. Judge Thornton read through them with an expression of growing disbelief. Miss Newhouse, he said slowly, did you attempt to claim Mr. Rosewood's private property in order to develop it for personal financial gain? Patricia stood up, her hands shaking. Your Honor, that business plan was just a preliminary idea. It was never meant to be taken seriously. It has nothing to do with the legitimate legal questions about the island's status. It has everything to do with it, Judge Thornton said coldly. You abused your position as HOA president to pursue a fraudulent property claim for personal enrichment. This is one of the most egregious cases of HOA overreach I have seen in my 30 years on the bench. He turned to the courtroom. I am ruling in favor of the plaintiff. Mr. Rosewood has clear and uncontested title to the island property dating back to 1892. The HOA has no claim to the property whatsoever. Furthermore, I am ordering the HOA to pay Mr. Rosewood's legal fees and damages for harassment and trespassing. I am also removing Miss Newhouse from her position as HOA president effective immediately, and referring this matter to the district attorney for investigation of fraud and abuse of authority. Patricia's mouth opened and closed like a fish. Gerald put his hand on her arm, but she shook him off. This is not over, she said, pointing at me. You think you won, but you have made an enemy of this entire community. You will never be welcome here. Miss Newhouse, you are dangerously close to contempt, Judge Thornton warned. I suggest you sit down and be quiet. Patricia sat, but she continued to glare at me with pure hatred. The judge finished by issuing a permanent injunction barring the HOA and all its members from accessing the island without my express permission. Court was adjourned. As people filed out of the courtroom, several residents approached me. To my surprise, many of them apologized. I am so sorry, Ethan, said the gardening woman from down the street. Patricia told us you were being selfish and preventing the community from using public land. I had no idea she was lying. Others echoed similar sentiments. It turned out that Patricia had misrepresented the entire situation to the community, making it sound like the island had always been public property that I was trying to steal. Now that the truth was out, the tide of opinion had shifted dramatically. The district attorney did pursue charges against Patricia. She was indicted on 2 counts of fraud and 1 count of criminal abuse of authority. Her brother-in-law Gregory was also charged as an accomplice. The trial took place 6 months later, and both of them were convicted. Patricia received 2 years of probation, 500 hours of community service, and a $10,000 fine. Gregory received a similar sentence plus restitution payments. The HOA held emergency elections and installed a new board of directors who immediately issued a formal written apology to me and rescinded all the previous actions taken regarding the island. They also implemented new bylaws requiring board transparency and prohibiting officers from using their positions for personal gain. As for me, I finally felt comfortable using my island again. I spent a few weeks that fall cleaning up the old stone cottage and making some basic repairs. It was peaceful and satisfying work. I also decided to do something that would have made my great-great-grandfather proud. I organized a community open house on the island. I invited all the Lake Geneva Shores residents to visit for 1 weekend, offering guided tours of the cottage and the history of the property. Over 100 people showed up, including families with children who were thrilled to explore the woods and shoreline. At the end of the day, I stood on the dock and addressed the crowd. I know the past several months have been difficult for everyone, but I want you all to understand something. This island has been in my family for over 130 years. My great-great-grandfather built that cottage with his own hands. This place has deep personal meaning to me, and that is why I fought so hard to protect it. But I also recognize that natural beauty is meant to be shared. So while this will remain my private property, I am opening it for community visits 4 times a year. Spring, summer, fall, and winter. You are all welcome to come, have picnics, enjoy the nature, and make memories with your families. All I ask is that you respect the property and leave it as you found it. The response was overwhelmingly positive. People thanked me, shook my hand, and several even hugged me. It felt good to finally be part of the community instead of fighting against it. The seasonal open houses became a beloved tradition in Lake Geneva shores. Children looked forward to exploring the island's trails and berry bushes. Adults enjoyed the peaceful atmosphere and the historical cottage, and I enjoyed sharing this special place with people who appreciated it. Patricia moved away from Lake Geneva about a year after the trial. I heard she relocated to Arizona and kept a very low profile. Her brother-in-law's development company went bankrupt during the legal proceedings. Richard Benton was elected as the new HOA president and did an excellent job of rebuilding trust and transparency in the organization. I still live in the lakefront house, and I still kayak out to the island several times a week. The old stone cottage has become my favorite place to work when I need absolute quiet and focus. On clear nights, I sometimes sleep out there in a hammock, looking up at the stars through the oak branches and thinking about my great-great-grandfather Cornelius, who had the vision to buy this little piece of paradise back in 1892. He could never have imagined the world of homeowners associations and legal battles that would come more than a century later. But he understood something fundamental about property and ownership that Patricia Newhouse never grasped. True ownership is not just a legal right, but a responsibility. You have to care for the land, respect its history, and pass it on better than you found it. That yellow deed from 1892, carefully preserved in my safe deposit box, represents more than just legal title to a few acres of land and water. It represents generations of stewardship, family history, and the simple but profound idea that some things are worth fighting for. One afternoon in early spring, about 2 years after the trial ended, I was working in the cottage when I heard a boat approaching the dock. I looked out to see Officer Martinez, now retired from the police force, waving at me from a small fishing boat. "Hope you do not mind the visit," he called out as I walked down to meet him. "I am not trespassing, am I?" I laughed. "You are always welcome, Officer Martinez." "What brings you out here?" He climbed out of the boat and shook my hand. "Call me David now that I am retired. I just wanted to see the place that caused all that commotion a couple years back, and to tell you something I probably should not have said while I was still on duty." "What is that?" I asked. "I thought what Patricia tried to do to you was garbage from day one," he said. "But you know how it is with civil disputes. Our hands are tied unless someone commits an actual crime. I am glad you fought back and won. Too many people would have just given up." "I had a really good lawyer," I said. "You also had a righteous case," David replied. "Mind if I look around?" I gave him a tour of the island, showing him the old-growth oaks that were probably seedlings when my great-great-grandfather first arrived, the wild raspberry patches that had been producing fruit for over a century, and the stone cottage with its hand-hewn beams and fieldstone fireplace. "This is really something special," David said as we sat on the cottage's small porch overlooking the lake. I can see why you were not about to let it go. It is more than just the property, I said. It is the principle. If Patricia could take my island just because she wanted it and had enough people voting with her, then nobody's property rights would mean anything. Today it is my island. Tomorrow it could be someone's house or their car or anything else the HOA decided it wanted. David nodded thoughtfully. You know what the crazy thing is? If Patricia had just asked you nicely if the community could occasionally use the island for events, you probably would have said yes. But she had to try to take it by force. Some people just do not understand that you catch more flies with honey. She did not want to ask, I said. She wanted to own it. There is a difference. We sat in comfortable silence for a while, watching the afternoon sun sparkle on the lake water. A family of ducks paddled past the dock, and somewhere in the trees behind us, a woodpecker hammered away at a dead oak. You did a good thing with those open houses, David said eventually. My grandkids came to the summer one last year. They talked about it for weeks. That is the kind of community spirit people actually want, not the authoritarian nonsense Patricia was pushing. After David left, I spent the rest of the afternoon working on a project I had been planning for months. I was creating a historical display inside the cottage, documenting the island's history with photographs, documents, and artifacts I had collected from my family. The centerpiece was going to be the original 1892 deed, professionally framed and preserved. I had also tracked down an old photograph of Cornelius Rosewood standing in front of the cottage shortly after he built it. He was a stern-looking man with a thick beard and work-worn hands, but there was something in his eyes that I recognized. Pride. Not arrogant pride, but the quiet satisfaction of someone who had built something meaningful with his own effort. Next to Cornelius's photograph, I placed one of myself standing in the same spot, taken just last month. 4 generations separated us, but we were connected by this island and the commitment to preserving it. The historical display opened during the fall open house, and it was a huge hit with visitors. Families brought their children to learn about what Lake Geneva had been like in the 19th century. Local history enthusiasts spent hours examining the documents and photographs. Several people asked if they could contribute their own historical photos and stories of the lake area, and I gladly accepted. The island had become more than just my private retreat. It had become a living museum, a connection to the past that helped people understand where they came from and what had been built by previous generations. And I had made it accessible without surrendering the ownership that Patricia had tried so hard to steal. The new HOA board under Richard Benton's leadership operated with a level of professionalism and respect that felt revolutionary compared to Patricia's reign. They focused on actual community improvements like road maintenance, organized neighborhood events like summer barbecues and holiday parties, and enforced reasonable standards without the petty tyranny that had characterized the previous administration. Richard and I became friends over time. He confessed to me one evening over beers at a local restaurant that he had been terrified to testify against Patricia. She had so much control over people, he said. Half the board was scared of her, and the other half just went along with whatever she wanted to avoid conflict. When I decided to talk to you and then testify, I genuinely thought I might get kicked out of the community or sued or who knows what. I am grateful you did it, I said. Your testimony was crucial. It was the right thing to do, Richard said. I just wish I had spoken up sooner, before things got so out of hand. Maybe we could have avoided the whole mess. Maybe, I agreed. But sometimes people need to learn lessons the hard way. The community learned what happens when you give someone too much unchecked authority. And hopefully, they will be more careful about who they elect to leadership positions in the future. The lessons from the island dispute rippled out in unexpected ways. Other HOAs in the Lake Geneva area reviewed their own bylaws and procedures, concerned about potential abuse of authority. The state legislature even proposed new laws strengthening homeowner protections against HOA overreach, though those got bogged down in committee and never passed. For me personally, the experience had been exhausting and stressful, but ultimately vindicating. I had stood up for my rights, fought against overwhelming community pressure, and won. More importantly, I had found a way to honor both my family's legacy and the legitimate desires of my neighbors to enjoy the natural beauty of the island. 3 years after the trial, I met someone who would change my life in ways I never expected. Her name was Olivia Edwards, and she was a historical preservationist working for the Wisconsin Historical Society. She visited the island as part of a survey of 19th-century structures in the Lake Geneva area and was fascinated by the cottage and its history. "This is incredible," she said, examining the hand-hewn beams and original stone fireplace. "Buildings like this are becoming increasingly rare. Most of them have been torn down or modernized beyond recognition. The fact that you have preserved it so carefully is really special." We started talking about the cottage's history, and the conversation stretched for hours. Olivia had a passion for historical architecture that matched my own love of the island's heritage. Before she left that day, I invited her to come back anytime she wanted to continue her research. She took me up on that offer. Over the next several months, Olivia became a regular visitor to the island. She brought equipment to document the cottage's construction techniques, interviewed me about my family history, and eventually wrote a detailed report recommending the cottage for inclusion in the National Register of Historic Places. Our professional relationship gradually became personal. We started having dinners together after her research sessions, then going for walks around the lake, then openly dating. Olivia understood why the island meant so much to me in a way few other people could. She saw it not just as property, but as a tangible connection to history and family. We got married in the spring, 4 years after the HOA dispute had finally been resolved. The wedding took place on the island, naturally, with the stone cottage as our backdrop and the oak trees providing natural shade for our guests. Richard Benton was there, along with many of the Lake Geneva Shore's residents who had supported me during the difficult times. Even Officer David Martinez attended, looking happy in civilian clothes. As Olivia and I exchanged vows on the same spot where my great-great-grandfather had built his cottage more than 130 years earlier, I thought about how differently things could have turned out. If I had given in to Patricia's demands, if I had decided the fight was not worth the stress and conflict, the island would now be a commercial event venue. The cottage might have been torn down or drastically remodeled. The ancient oaks could have been cut down to make room for parking areas and rental facilities. Instead, the island remained what it had always been: a quiet refuge, a piece of living history, and now the beginning of my new life with Olivia. We honeymooned in Europe, but were both eager to get back to the island afterward. Olivia had been approved for a grant to write a comprehensive history of settlement-era buildings in Wisconsin, and the cottage was going to be one of her primary case studies. I continued my software development work, but I also started volunteering with a property rights advocacy group that helped homeowners fight back against HOA overreach. The advocacy work was surprisingly rewarding. I heard from people all over the country who were dealing with situations similar to mine. Petty tyrants using HOA positions to bully and control their neighbors. associations making unreasonable demands, and boards operating with zero transparency or accountability. While I could not take on every case, I offered advice, connected people with good attorneys, and occasionally testified as an expert witness about my own experience. One case particularly stuck with me. An elderly veteran in Florida was facing foreclosure because his HOA claimed he owed thousands in fines for painting his house the wrong shade of beige. The whole thing was clearly a vendetta by an HOA president who had a personal grudge. I connected the veteran with Margaret Chen, who agreed to take the case pro bono. They won, the foreclosure was blocked, and the HOA president was removed from office. It felt good to help someone avoid the kind of harassment I had experienced. 5 years after the trial, Lake Geneva Shores held a community anniversary celebration. As part of the event, they installed a small historical marker near my property acknowledging the island's history and its connection to the area's settlement era. The marker included a photograph of the original 1892 deed and a brief text explaining how the property had been continuously owned by the Rosewood family for over 130 years. At the dedication ceremony, Richard Benton gave a short speech. This marker represents more than just one family's property. It represents the importance of respecting history, honoring legal rights, and recognizing that sometimes the old ways got things right. We are fortunate to have Ethan and Olivia as members of our community, and we are grateful that they continue to share this special place with all of us. It was a far cry from the hostile community meetings and anonymous threatening letters I had endured during Patricia's campaign. The transformation was remarkable and gave me hope that communities could learn and grow from their mistakes. Olivia and I eventually expanded the historical programming on the island. We started offering educational sessions for local schools, where students could learn about 19th century building techniques, early Wisconsin history, and the importance of historical preservation. Teachers loved it because it gave students a hands-on connection to history that they could not get from textbooks. We also partnered with the local historical society to create a small museum exhibit about the island and the Lake Geneva area's settlement period. The exhibit included artifacts from the cottage, photographs, documents, and interactive displays. It became one of the society's most popular exhibits, drawing visitors from across the state. The island itself remained largely unchanged. I resisted any temptation to modernize or develop it beyond basic maintenance and preservation. The cottage got a new roof using period-appropriate materials. We restored the original windows rather than replacing them with modern ones. The dock was rebuilt using the same design my great-great-grandfather had used. Every decision was made with an eye toward preservation and historical authenticity. Olivia sometimes joked that I had become as protective of the island as a mama bear with cubs. She was not wrong. After fighting so hard to keep it, I felt an even deeper responsibility to preserve it properly. This was not just my property anymore. It was a trust I held for future generations, a piece of history that needed to be protected. 10 years after the initial HOA dispute, I received an unexpected letter. It was from Patricia Newhouse. I almost threw it away without reading it, but Olivia convinced me to at least see what it said. The letter was surprisingly humble. Patricia wrote that she had been in therapy for years, working through issues related to control and ego. She acknowledged that her attempt to claim the island had been wrong and motivated by greed rather than any legitimate community interest. She apologized for the harassment, the vandalism she had encouraged, and the stress she had caused me. "I do not expect forgiveness," she wrote, But I wanted you to know that I understand now how wrong I was. What I did was not just legally wrong, but morally wrong. I abused a position of trust to pursue personal gain, and I hurt someone who had done nothing to deserve it. I am deeply ashamed of my actions, and I am sorry. I read the letter twice, then showed it to Olivia. "What do you think?" I asked. "I think people can change," she said carefully. "Whether or not you want to respond is entirely up to you." I thought about it for a few days. Finally, I wrote a brief reply. I acknowledged her apology and told her I appreciated her taking responsibility for her actions. I did not say I forgave her. I was not ready for that, but I wished her well in her continued growth and recovery. I never heard from Patricia again, but writing that response gave me a sense of closure I had not realized I needed. The anger and resentment I had carried for years started to fade. She was no longer the villain in my story, just a flawed person who had made serious mistakes and was trying to do better. Life moved on. Olivia and I talked about having children and what it would mean to raise them with this incredible historical legacy literally in our backyard. We imagined teaching them about their great-great-great-grandfather Cornelius, showing them how to identify different types of oak trees, taking them fishing off the dock on summer mornings. The island had been many things over its long history. A private retreat, a source of family pride, a point of bitter legal conflict, a community gathering place, an educational resource, and a historical treasure. Through all of it, one thing remained constant: the yellow deed from 1892 that proved beyond any doubt who owned this little piece of paradise. I kept that deed in a climate-controlled safe now, along with all the other historical documents related to the property. But I also kept a certified copy framed on the wall of my home office, where I could see it every day. It reminded me of where I came from, what I had fought for, and why some battles are worth fighting no matter how difficult they become. Standing on the island dock on a warm summer evening, watching the sunset paint the lake in shades of gold and crimson, I felt profoundly grateful. Grateful that Cornelius had the foresight to buy this place back in 1892. Grateful that my family had preserved it through wars, depressions, and dramatic social changes. Grateful that I had found the strength to fight for it when someone tried to take it away. And grateful that I could now share it with others in a way that honored both its private ownership and its public value. The HOA dispute had been one of the most stressful experiences of my life, but it had also taught me invaluable lessons about property rights, community dynamics, standing up for principles, and the importance of historical preservation. Those lessons shaped not just how I managed the island, but how I approached life in general. And every time someone visited the island for one of our open houses, every time a student learned something new from our educational programs, every time I kayaked across the water and stepped onto that rocky shore, I remembered why it had all been worth it. Some things are simply too important to give up without a fight. Family heritage, property rights, historical preservation, and the fundamental principle that justice should prevail over power. The island was all of those things and more. It was my sanctuary, my responsibility, and my gift to the future. And thanks to a yellow deed from 1892, and a good lawyer who believed in the rule of law, it would remain in the Rosewood family for generations to come, just as Cornelius had intended when he signed that deed more than 130 years ago.